Good morning, students. In our previous class, we have started the fifth lesson of civics, that is judiciary, the third organ of the government. In this, we have read and understood about that the rule of law, which means that law apply equally to all persons. And to enforce this rule of law, we have seen that judicial system is there, and that judicial system is a mechanism, is a process of courts that every citizen can approach easily when a law is violated. And in this, we have further seen in a previous class that what is the role of judiciary, what all functions the judiciary do, and these functions can be broadly divided into three parts. That is, judiciary dispute resolution is there. That means judiciary provides the resolution for any disputes, any type of disputes or conflicts which are arose among or between the citizens, or between the citizens and the government, or we can see uh, we can say that between the two states of the government, or between the center and the state. Any type of conflict which is arise, or any type of disputes which are arose among them, it can be sought out by the judiciary. Second, we have seen about the judicial review, in which we have seen that the final interpreter, the final decision, uh, or final changes which can be made, it is by the judiciary only. If any law which is passed in the parliament, and it is thought that that law is it means it destroys the peace of the country, then the basics or the basic structure of the constitution is uh, violated, then the judicial review, then the judiciary has the power to see back again that particular law. Then third role, we have seen about upholding the law and enforcing fundamental rights. In this, we have seen that every citizen of India can approach the Supreme Court or the High Court if he or she thinks that the fundamental rights have been violated. And even the compensation, the judicial system can ask for the compensation. Now, what is the word compensation means? It means the money given to make any type of amendments for any injury or loss. I mean, any injury or loss to anybody has been made, then the court can ask for the compensation for the uh, to pay the money back. Here we have also seen that the Supreme Court was established on 26 January 1950. It was the day when India became the republic. Then next, independent of judiciary, also we have seen this topic in a previous class only. We have understood that yes, we can say that in India, independent of judiciary is there, and just because there is independence of judiciary, which allows the courts to play the central role. That means uh, it allows that no misuse of power of the legislative or executive is there, and everyone everywhere can they work uh, independently, and it also protect us. The judiciary also protect us by ensuring the fundamental rights, by providing us the fundamental rights. And if anybody thinks that the fundamental rights have been violated, they can easily approach the courts. Then third, next topic, we have seen about the structure of courts. What are the structure of courts? In which we have seen that the first level is the tehsil level, or we can also say that the subordinate courts or the district court is there at the first level. Then, if the person is not satisfied with the uh, judgment of this subordinate or district court, then they can move to high court for the further judgment. Then again, if then also the person is not satisfied with the judgment for the high court, which is given for the by the high court, then they can also move to Supreme Court. And the Supreme Court is located in New Delhi, and it is presided by the Chief Justice of India. Then we have also seen that the decision made by Supreme Court should be followed by in all the courts of the India. So here In this triangle form, we have seen that the lowermost court is subordinate or district level, then the High Court is there, and the Supreme Court is there. Final. Here in the side box also, we have seen that the High Court was first established in three presidency cities, that is Calcutta, Bombay, and Madras, and the year is 1862. So in 1862, this High Court was first established. You can make a note here. Then next are we have seen about the incident, the Lakshman Kumar's case, where his wife Sudha Goyal was burnt by the in-laws, and for this they were the case was filed. In this, the case was filed by the Sudha's family members, and the case was filed in the trial court. And the trial court, uh, it was the Lakshman, and the trial court had given the judgment that the Lakshman, Mother Shakuntala, and the brother-in-law Subhash Chandra were three of them were found guilty, and they were sentenced to death in the trial court, which was the case which was filed by the Sudha's family members. But the Lakshman family members were not at all ready to see this judgment fair, and they again filed a case against this to the High Court. And then final, the High Court had given, they filed a case in the High Court, and the High Court then gave the judgment that Lakshman, Shakuntala, and Subhash Chandra the was not found guilty for the case of Sudha's, uh, uh, for the burnt case of Sudha. And that is why they were not found guilty in High Court. Previously, in trial court, they were found guilty, they were sentenced to death. But they again filed a case that Subhash, brother-in-law, plus Shakuntala, mother-in-law, and Lakshman, they filed a case against the family members of Sudha in the High Court, and now High Court had declared that they were not found guilty. That means acquitted means they were not found guilty. Again, that case was taken into consideration by the Supreme Court now. Now the Sudha's family members again filed a court against them, and finally, as the judgment of the Supreme Court is the last judgment. That means the Supreme Court now decided to send the accused. That means Lakshman and his Lakshman, the husband of Sudha, mother-in-law Chakuntala, both of them were sent to life imprisonment by Supreme Court. But brother-in-law Subhash was not found guilty because there was no evidence, no proof against brother-in-law. Now today we are going to start with different branches of legal system. Now as we know that there are different branches of legal system also, that is the crime against society is being done. In the case of Sudha, we have seen that the crime against society has been done, and the death was due to the dowry, and that is why it was the criminal law, that is the violation of the criminal law. And next you will read about the civil law also, which was passed in 2006. And this civil law, you have read about that Domestic Violence Act to protect women against domestic violence. Now the two table you will find out the difference between the criminal law and civil law. Now criminal law deals with the conduct of acts that law defines an offense. That means it is really a great offense, great violation of the law. That means in this, the cases like theft, harassing a woman, or bring more dowry, or the murder. These are the cases which will be involved as a criminal law. Then again, criminal law, it is usually begins with the lodging of the FIR. That means first information report. First information report has to be lodged in the police station. Then only the police will be investigating on the particular crime. So first and foremost, the criminal law. Which are the criminal laws? Which cases will be heard in the criminal law? That is theft, harassing a woman, or to bring dowry or the murder. These cases will be involved for the criminal law. And for the criminal law, first information report is necessary, that the person should lodge the first information report, then only the police will start its investigation. And finally, if the person is found guilty, if the guilt has been proved, then that person will be sent to jail, or can also be fined, means a sum of money can be asked from that particular person whose guilt has been seen, proved. Next, civil law, it deals with the harm or injury to the rights of individuals, means any harm or injury to the individual is done, it will become concerned with the civil law. An example is given: disputes related to the sale of the land, purchase of goods, rent matters, diverse cases. All these cases will be heard in civil law. And a petition means a plea is first filed before the court, and then the court will give the decision. In the rent matter, either the landlord or the tenant can file a case. That means if the matter of rent is there, that a tenant is not paying a rent to the landlord, that means either the rent tenant can file the case, or the landlord can file a case. Means any one person had to file a case, or had to give the petition to the court. Then next, the court gives the specific relief asked for. Now the conclusion is that if once the petition is filed in the civil court, then the court will give the specific relief for that particular person who has filed the case. That means in the case of landlord and tenant, the court can order the flat to be vacated, the pending rent can to be paid by the this person who is a tenant on the in the place of landlord. So the decision of the court will be final here. Either the tenant had to leave the place and go, or he had to pay the whatever pending rent is there, he has to pay to the landowner. So this type of civil cases will be heard under the civil law. Another topic now: does everyone have the access to court? That means, that shows that it is said that yes, everyone is can easily go to courts to, if any type of violation to their fundamental rights, or any type of they want justice, they can go easily to the court. But is this really happening, that all citizens of India can access the court? This implies that every citizen has the right to justice through the court. That means we can say, yes, it is correct to say that every citizen has the right to justice. You can underline this: every citizen has what? Every citizen has right to justice through the courts. Every citizen has right to justice through the courts. And this uh, as you have read earlier, the courts play a specific role in the protecting the fundamental rights. Courts also protect, it is the important function of the court, the judicial system, to protect our fundamental rights which have been provided to us by the Constitution. And if any citizen believes that the rights have been violated in any case, then they can go to the courts for the justice. While the courts are available for all, in reality, access to courts have always been difficult for the vast majority of poor in India. Now, as we say that yes, courts are accessible to all the citizens. Anybody can approach the court for asking the justice. But in reality, if we say that the courts have been always difficult for the vast majority of poor in India, means poor people could not go easily, because the legal procedures involve a lot of money. Whatever procedures are there to file a case and all, it spends a lot of money for that. And the poor people cannot afford all these legal procedures, which on which they had to spend a lot of money, because most of the poor people depend on the daily wages. Daily wages means daily they are earning, they are going daily to for the work, and daily whatever they are doing work, they are getting the money that much only, and they can't spend so much money for the legal procedures and all, if they really want the justice. And another thing is that even lot of paperwork is also there, and when the lot of paperwork is also there, that means uh, many poor people, they are illiterate, they do not know how to read and write, and that is why they feel little bit means very difficult to approach the court or to go through the papers and all, paperwork and all. In response to the Supreme Court in the early 1980s devised a mechanism of public interest litigation. That means a process was organized, a process was came into being, that is established by the Supreme Court. Which was that process which was established by Supreme Court? It was the public interest litigation. That means the public interest was kept in mind, so that it was easily, the court process can become easily accessible, easily reachable by the poor people also, and poor people can also get the justice. So this public interest litigation was started by the Supreme Court, so that each and every person, whether rich or poor, can easily reach and to the courts and get the justice. And they can just get the justice means the individual or the organization can file a PIL, that is public interest litigation, in the High Court or Supreme Court on the behalf of those rights were being violated. Means if any of the rights have been violated, they can easily go to the Supreme Court or High Court. And the method is also very much simplified. Easily, in the simple way, they can either use a letter or a telegram to address the Supreme Court about their difficulty, about their problem, and they can file a case in PIL, that is public interest litigation, and they can get the justice. In the early years, PIL was used to secure justice. In the early years, it was used to secure the justice, that means to provide the justice to the poor people, such as the bounded labor. Bounded labor are the poor people which work in the conditions, bad conditions, in which they are forced to work for the particular person, and there to apply for the justice, they can now easily file the case in PIL. And even another example is given that after the punishment term was completed, the prisoners were kept in Bihar jail, uh, and they can also, uh, according to public interest litigation, they can also go for the justice. Now, did you know that the midday meal that children now receive in the government or government aided school is because of PIL? That means now you can understand that the midday meal, which is started by the government in the government schools and all, or government aided schools and all, for the small children, so that once a day at least these children can have the nutritious food to eat. And in another sense, they can also get the education uh, uh, in these schools. So this thing was also started in public interest litigation only. For the common person, access to court is access to justice. Now, the common person, if they easily reach to courts, they can get the justice easily. The courts exercise a crucial, very important role. The courts uh, exercise a very important role in interpreting, in giving the fundamental rights of the citizens, in protecting the fundamental rights of the citizens. And we can say that Article 21 of the Constitution on the right to life, to include the right to food. That means right to life and right to food is given by Article 21 of the Constitution, that every person has the right to life. Then, however, there are also courts judgment that the people believe work against the best interest of the common person. That means whatever things are more important for a common person, the judgment is given by the courts accordingly. And for example, is given an activist who work on issues concerning the right to shelter, the housing for the poor, believe that the recent judgment on eviction are far cry from earlier judgment. That means previously it was very much difficult to give the judgment on the eviction. Eviction means here means the removal of the person from the land or home in which they are currently living in. That is the word eviction means, that you are forced to move away from that particular land or from that particular house in which you are currently living. And that time, in earlier judgments and all, it was very much difficult to give the judgment up for that. But nowadays, as the right to life and right to food is given, provided by the Indian Constitution, so the recent judgment says that the slum dwellers, who are the slum dwellers? Slum dwellers are the people who are living in filthy areas, the dirty areas, and they are the encroacher. Encroacher, I had already given the meaning of that encroacher. The word encroacher means the to enter forcefully in the particular part of the city. These slum dwellers, these poor people had entered a particular part of city and they started living over there. And previously it was easily, they were easily removed, but now it is difficult to remove them in whichever area, part of the area of the city they are living in. And the case is given of Olga Tellis versus Bombay Municipal Corporation. This case is given that the judgment of Olga Tellis versus Bombay Municipal established the right to livelihood as the and as a part of right to life. That means now people anywhere if they are living, they are not forced to leave that particular area in any case. If in case they are removed, they had to be restored or had to be given another area to settle themselves. But first and foremost, they are not able to remove in any way because right to life is there. If they will be removed, even they will not have their jobs because particular area they are living, they are having the jobs also they in that particular area only. And that is why it is now not easy because right to life is provided to each and everyone by the Indian Constitution according to Article 21. And that is the eviction of the person from the permanent pavement or the slum will inevitably led to the deprivation of the means of livelihood. That means if we remove a particular person from the pavement or the slum area, that means we are depriving, we are taking the means of livelihood of that person. And that means we are violating one of the law of Indian Constitution. So this was the case, and they choose the pavement or the slum in the vicinity of the palace of place of the work, and to lose the payment or the slum is to lose the job. That means if they had to be removed from the payment, they had to be out of the job also because they will be no jobs for them. They are doing the job there only. They are providing the services in that particular area only. So the conclusion, therefore, is that the eviction of the petitioner will lead to the deprivation of the livelihood and consequently to the deprivation of the life. That means if they are really removed, these slum dwellers are removed from that particular area, that means you are violating the uh, right to life for that particular slum dwellers. Now, another issue that affects the common person access to justice is inordinately long number of years that courts take to hear the case. Now, another issue which is that why common person avoid going to courts and try to settle disputes among themselves only is the long number of years. It takes a number of years, means much time to give a decision by the court. That is why people mostly prefer to solve the dispute, to resolve the dispute among themselves only, rather preferring to go to the courts. And that is why this is the reason why the common person is not going to the courts easily to sort or to get the justice or to sort out any problems. The phrase justice delayed is justice denied is often used to characterize that extended time provide that courts take. That means the phrase, which is the phrase that justice delayed is justice denied. That means the justice, if given, if takes the long time, it takes the long time to provide justice by the court. That means it is seen that it is totally denied. The justice is being not provided to the particular person. However, in spite of this, there is no denying that the judiciary has played a crucial role in democratic India, serving as a check on the powers of the executive and legislature as well in protecting fundamental rights of the citizens. The members of the Constituent Assembly had quite correctly envisioned a system of courts which with an independent judiciary as a key feature of our democracy. That means till now we are having independent judiciary, which is the key feature of our democracy. And due to this independence of judiciary only, uh, it provides a type of check on the powers of executive and legislature as well. It provides the protection of the fundamental rights to each and every citizen. Now, this was the here we come to an end of the lesson. This was the last lesson to be completed for periodic 2. Now question answers, I'm going to give it to you in the PDF form today only. You can open the PDF and do all the question answers in the notebook neatly. For notebook assessment, you have to do all the question answers neatly in the notebook, make PDF of it and upload it on the Google form link provided to you for the work submission. Each and every lesson which is coming in periodic 2, you have to upload it. Whatever lessons you have uploaded earlier, no need to upload that again. You have to upload the periodic 2 lessons for the work submission for the notebook assessment. And the question answers of this lesson, I am going to give it to you in the PDF also in the group as well as on the student portal. You can open the PDF and you can do it the in the notebook neatly. If any doubt, you can ask me on the group in the group also, or personally you can call me. Thank you.